please, Your Lordship. Learned friend Miss Ayres appears for the respondent to this appeal, and I represent the appellant together with my learned friend Mr. Tazio. My Lord, can I just begin with some housekeeping, just to check that Your Lordship and Ladyship have all the documents that you need. There's a core bundle which runs to 288 pages.
Yeah, we got all the bundles, but we haven't got a supplemental bundle, right?
No.
No. Okay. Good.
There's an authority bundle,
yeah,
which needs to come with an apology, I'm afraid, straight away, because as Your Lordship will have noticed, unfortunately, most of the reports are transcripts.
Doesn't contain any reports. It's very annoying, actually. But
it is. Well, I'm sorry, my learned friend spotted it, but I'm afraid too late. We did offer to change the bundles, but by then I think it was too late.
We'll manage.
Thank you. Key documents in the core bundle. There are skeletons. The respondents is at page 51 in your bundle.
Yeah, I use them separately anyway. You don't need to go through.
There's a slightly amended version of the appellant's skeleton, which I hope Your Lordship has. Yeah. And the reason for that is, I think, explained in it. There's an agreed note of the hearing before Master Thornett on the 2nd of December 21, including a note of his judgment, which begins at page 25, to explain why there's a note rather than the transcript.
We know why.
Thank you.
We have read the papers, Mr. Counsel.
Right.
It's quite an interesting and difficult appeal, so let's get to it.
Certainly.
Yeah.
Well, then I'll move swiftly on. Your Lordship would have seen why we're here and what the claimant's claim is, to claim for damages for sexual abuse by a karate coach. The claimant obtained a default judgment on the 22nd of September. The chronology is set out in the skeletons, and I see Your Lordship nodding, so I won't take you to them. Master Thornett, having heard argument in a slightly disrupted hearing, I'm afraid, it was a remote hearing in which there
was it all remote?
It was remote, yes.
It was all remote. I mean, it sort of had the sense to me of the bad old days when you went into the Master in 1981 and you were sort of blasted out before you'd even got in the room. But it wasn't that, it was online. It was online,
and I think there was a difficulty with connection at the beginning, and so
right,
the time taken was foreshortened. I'll be corrected by my learned friend if I'm wrong, because she was there. I wasn't there.
No. You were there.
And so was my learned friend, Mr. Tazi.
Right.
And Your Lordship sees how it begins. Master Thornett gets stuck in, if I may say so, straight away as to the reasons for delay and so forth.
Put me in mind of Master Waldman. I don't know if you remember him.
My Lord, can I start by taking you though to the judgment? It's at page, the judgment part of the note starts at page 25. And there's
do you say that he applied Denton or not?
He didn't apply Denton, no, we say.
Well, don't you need to start with the transcript of what he did say? Because that's the bit that... So you've got the judgment starting at 25, but
yes.
You have to look at the introductory bit where he says somewhere Denton's really important.
He does. He does, and indeed in the judgment bit, if I can call it that, he again refers to Denton at page 27.
Well, 22, Denton is raised, albeit by counsel.
Yes, it is.
Specifically raised.
My lady, the position is this, that in the claimant skeleton, Denton is dealt with in some detail, together with the criteria that are necessary. It isn't dealt with at all in the second defendant's skeleton argument, nor in the witness statement from Mr. Gillespie. There's no
your junior said this is a Denton application.
He did. Master, my Lord, it's not my case that the Master was unaware of Denton. He just didn't apply it when it came to it. He had a discussion with counsel about the reasons for the delay and so forth, but he didn't apply Denton when it came to it, which is why, if I may, I was going to
So you say it doesn't matter what anybody said. he didn't apply Denton.
No, he didn't. Can I
Yeah.
take your lordship to page 27 and pick it up in the middle of the page, where he says, however, I turn to the express primary requirements of 13.31. Mr. Tarzan refers appropriately to Denton and its criteria. So there's a reference to it, even in the judgment.
Sorry, I'm a bit behind.
No, it
Which
begins with the
paragraph?
paragraph,
27?
however, page 27.
Which
So
paragraph? I turn to the necessary. Yeah,
That's
okay,
the
got
one.
it.
Mr. Tarzan refers appropriately to Denton and its criteria, but the familiar criteria of Denton are qualified because of necessary incorporation into the context and the express criteria under 13.3. In particular, the criterion of real prospect of successfully defending the claim. The first question, he says, is whether there is a real prospect of successfully defending the claim or some other good reason judgment should be set aside. The second defendant does not raise some other good reason. In addition, then, as a sequential factor under sub-rule 2, I must have regard as to whether the application was made promptly. So that's looking at, of course, the two relevant factors in 13.3.
Yeah.
I'm quite satisfied that it's not being made promptly, and there's no good reason in support of the delay. My reasons for being satisfied should be clear from the exchanges with Miss Eyre. But as to whether the second defendant has a real prospect of successfully defending claim, it's clear that the case on vicarious liability would be both arguable and sophisticated. And then, in the next 3 paragraphs, 2.5 paragraphs, he deals with why he comes to that view. So he's dealt there with 13.3. He then comes back, if I can pick it up at such latter observation. I'm satisfied. Such latter observation, I'm satisfied, seems ultimately to illustrate that for the purposes of 13.3, there is a reasonable prospect of defence on the basis that vicarious liability does not arise. The necessary factual analysis might well be amenable to, even requiring of, further elaboration. I cannot forestall that process now. Instead, for the purpose of this application, I find it's arguable and have reasonable prospects. And then he says, I have to add that it would also have passed that threshold had the application been made sooner. Therefore, the delay in making the application, as I'm obliged to have regard and as I have been satisfied, plainly arose without any convincing explanation. Ultimately, I find, does not eclipse the merits of the proposed second defendant's defence. So what the Master is doing there, with respect, is applying 13.3. He's looking at whether or not there are realistic prospects of success. And then he's balancing that, as he's required to do under 13.3, by reference to sub-rule 2, in considering whether to set aside or vary a judgment. The matters to which the court must have regard include whether the person seeking to set aside the judgment made an application to do so promptly. He then has a paragraph on limitation, which I might say slightly out of turn, but there it is. And he then goes on to give his decision, and then he deals in the remaining part of the judgment with the form of the order and costs and so forth. And so my submission in answer to your Lordship's question is that yes, there is reference to Denton, but he doesn't apply Denton. He doesn't do what your Lordship said should be done in Gentry, which is then go on to consider the Denton criteria as they are set out in Denton.
No, but I mean, plainly he doesn't. But I mean, he deals with first Denton criterion because he says that the delay is not explained, is effectively serious and not explained, right?
He does, but he doesn't.
He then considers everything else in the case and seems to think that the fact that there might be a good defence is a jolly good reason for setting it aside. Now, is that wrong? Does Denton say anything? Is there anything in Denton that says if real injustice would be perpetrated, sometimes that wouldn't be allowed to take the to hold sway?
Well, what of course Denton says is that there are three questions one needs to ask.
Yeah, but he's effectively done the first two.
Well, there's no, with respect, there's no discussion whatever that of whether or not there's a serious or significant breach.
Well, except he says it is. I mean, he says, I mean, there is really, because he says, I mean, the breach is the period of delay before they in failing to file a defence, the initial breach, and then the period of delay in applying to set aside. And he says, I'm quite satisfied the application's not been made promptly and there's no good reason in support of the delay.
Well, that first part, of course, is 13.32.
Yeah, well, I agree it sort of is, but he then refers back to his exchanges with Miss Ayres. Where are they? Have we got those?
We do. I mean, that's the first part of the note that your lordship has, and it's quite a lengthy question.
Well, that
answer.
presumably deals with all the delay in filing a defence and the delay in making the application to set aside, all of which were serious, significant delays, breaches.
Yes, but Mallow, what he doesn't do is, having carried out that analysis, which he conducts perfectly properly in relation to 13.3, what he doesn't do, as in my submission he should have done, is then say, right, that's that stage. I now need to look at the fact of the Denton criteria. Was there a serious or significant breach?
I completely accept that, Mr. Counsel. Can I ask you this?
Yep.
If you're right, and he didn't apply Denton, and Denton is applicable, then we do it again. That's easy. If you're wrong, and he did apply Denton, what happens? What is the status of the appeal in the Court of Appeal as opposed to an appeal before the judge? Because this case should have really been before the judge.
In other words, is your lordship asking me whether you should decide it for yourself?
Do we have to decide whether if he applied the right test, and he didn't, there's no other sort of fundamental error, then we would presumably defer to his judgment.
Well, it isn't a ground of appeal that if he applied the right test, that he got it wrong anyway.
So the only actually ground for, well, your ground for appeal is a tiny bit rolled up.
Yes.
Can I just look at it? You say he was wrong in law as to his approach. So you say, well, if he was right in law as to his approach, you lose, really.
Yes, to an extent, although what we would submit is that he can't have properly considered Denton, because if he had done so, he wouldn't have reached the decision he reached. If he'd properly considered those considerations.
And I have to tell you that I am influenced by spending 10 years of my life in the Master's corridor, albeit that it was a jolly long time ago. And Masters would be horrified if they were told by the Court of Appeal they had to spell out something as common or garden as Denton in every judgment. They, having been told by the Court of Appeal in no very uncertain terms what the rule was, and his having said Denton applies, I mean, what Miss Ayres says is it doesn't apply. You'll presumably address that.
I certainly will. But I'm trying to address your lordship's point first. What we say is he didn't. There are a number of factors here which he just simply didn't look at all, in particular in relation to the criterion 3, in relation to consideration of all the circumstances. In the claimant's skeleton argument for the hearing, the claimant set out some of the circumstances which were relied upon, and there's no discussion of that at all. And of course, consideration 3 is of critical importance in my submission, as is set out in Denton.
But, Mr. Counsel, can I just take up the point that my Lord the Master of the Rolls was making? If one looks at page 24, really the first substantive paragraph, and it comes from the Master. On the Denton point, it is not controversial to say that Denton permeates every action relating to a breach of the rules. He allows for the slight qualification of 13.3, and then says, but that doesn't mitigate Denton. Does that not perhaps suggest his approach? He's accepting that, as he puts it, Denton permeates all this. He may not have gone through quite the stepping process that has been identified in the authorities, but that was his approach.
Well, certainly during the course of hearing submissions, he does say that.
Yes.
But my focus is on his the decision-making process which he goes through in the judgment. Because it may very well be the case that he gives consideration to criteria 2, namely the reasons for the breach, but he doesn't deal, in my submission, perhaps less importantly, he doesn't deal with whether there's a serious or significant breach, but most important of all, he doesn't look at all the consideration of all the circumstances. And as Denton makes clear, that is a extremely important part of the test itself. Could I?
Well, possibly we're going round in circles. I mean, I think we will have to look at this in the round in due course. But I suppose you have to anyway deal with the argument against you, which is that Denton doesn't apply. And you say, which is always helpful, well, you, Master of the Rolls, said it did, so obviously it does. And I'm fairly sympathetic to that argument in relation to Gentry, but in Gentry, Matthews was not cited, and we didn't have the benefit of Mr. Dias's and Mr. Justice Baker's detailed analysis. What do you say about all that?
Well, can I just, if I may, including my submissions on the other points, but I'll come straight on to that. Can I just remind, I'm sure your Lordship doesn't need reminding, but can I just take you to Denton briefly? And it begins at page 3 in your authorities bundle. Unfortunately, only the transcript. And at page 14, they're dealing, your Lordship and the Master of the Rolls.
Page 40 of what?
Page 14 of the bundle. Which
14.
Paragraph 31 of the judgment of your Lordship, I think, and the then Master of the Rolls, is dealing with the third stage, so all the considerations. What is said there is the important misunderstanding that has occurred is that if there's a non-trivial, now a serious or significant breach, and there's no good reason for the breach, the application for relief from sanctions will automatically fail. That's not so, not what the court said in Mitchell. Rule 3.9 requires that in every case, the court will consider all the circumstances of the case so as to enable it to deal justly with the application. We regard this as the third stage. And then in paragraph 32, without reading it all, what is set out is that the third stage is of extreme importance and that the court should consider that as a separate exercise. Now, whatever one may make...
You say he didn't do any of that.
He didn't do any of that. There are all sorts of considerations, some of which were raised in the claimant skeleton argument, which he simply didn't consider, and he should have done. And we would say that if he had done, then he would have come to a different decision because of its importance. For example, I only give it as an example, the effect upon the other parties of setting aside judgment. As your Lordship will have seen, this was a claimant who had suffered sexual abuse, and delay in a case like that is perhaps all the more difficult than it would be in another case. And of course, there's another defendant who is waiting to see what should happen. All those, the effect on the court system of breaches such as this, and all of those factors were never discussed at all, because we would say the master didn't approach the exercise that he was being invited to deal with in the appropriate way, notwithstanding, except that he refers to the test in Denton, and he refers to the absence of a proper explanation for the failure to serve a defence. Those are my submissions on that.
And you say this is a case where preeminently we're seeing lackadaisical conduct of litigation, and that was what Denton was addressing, that's what Mitchell was addressing, and there seems to have developed a parallel universe, which you would say was not intended when we came to deliver our judgments in Denton. And time to stop it,
yes.
I would say.
That's itself one of the considerations to take into account. It's expressly set out, I think.
Well, I'm sympathetic to that approach, at least,
yes.
in the sense that it's perfectly clear what we intended by Denton, and I had no knowledge until I saw this case of the parallel universe that had developed alongside it.
Yes, this we would say with the greatest of respect, and obviously it's easy to criticise, but the breaches, the failures in this case were pretty extraordinary.
But they were, in the old days they wouldn't have been extraordinary
right.
at all, but in the new era, I see that. I mean, why were they so extraordinary? I mean, they were, we're talking about what, 2 months. 2 months in not having a proper extension of time for the defence and not going to court. So then they get warned, and then judgment's entered, and then another month or two before they apply to set aside.
This is, with respect, pretty extraordinary that when having been told that the claimants had made a request.
And these are solicitors, right?
This is Keir's.
These are defence solicitors.
Yeah.
This is what they do.
This is their particular sphere of expertise, defending these cases. Why not?
So maybe they weren't taking Denton very seriously.
Who knows?
Yeah. Yeah, okay.
Weren't they in fact the solicitors in Gentry?
They were. They were the same firm.
Yes.
I don't think it was the same.
I'm sure not. I'm sure not.
Not the same person.
No.
Shall I move on then to deal with why we say that Denton applies to an application to set aside a default judgment? We say that it plainly does, and as your Lordship's already said, we do rely on a number of authorities. The first of which, and I'm looking at paragraph 34 of our skeleton argument, the first of those is Hussain, which actually predated Denton, a judgment of Lord Justice Chadwick in Hussain and Birmingham City Council, which your Lordship has in the bundle. I'm not going to take your Lordship particularly to that case. Since the decision in Denton, we say there are 3 Court of Appeal authorities which have considered the relevance of Denton to applications under 13.3, all of which we say support the claimant's position. The first of those is Regioni Piemonte and Dexia Crediop, which I'm going to shorten, if I may, to Piemonte. The second is Blakemores, which is a decision of your Lordship with which Lords Justice Underhill and Morbeck agreed. And then, of course, there's Gentry and Miller itself. In all 3 of those Court of Appeal cases, the court held that applications under 13.3 engaged the Denton principles, although, of course, it's right to point out that in Blakemores and in Gentry, your Lordship didn't hear full argument on that because it was agreed.
Well, you say that. You say that, but it was agreed, but it was agreed in a sort of, the judgments are pretty firm on it. you know, they don't, it's not like an obiter that is just something, oh, well, we haven't thought about this, but if council agree, we'll take it as the premise for the decision. I mean, the reasoning in paragraph 23 or whatever it is in Gentry is quite clear, isn't it?
Yeah, but I'm not going to argue against that for obvious reasons.
Yeah, well, we'll have to hear from
Yeah.
them, obviously.
Can I take you to Piemonte though? Because I think it's suggested by my learned friend that actually this case supports her submission.
Look at it.
Can I take you to, it begins, Piemonte begins at page 48 in your authorities bundle.
Mm-hmm.
And can I take you straight away to paragraphs 39 and 40, which are at page 60. This is the judgment of Lord Justice Christopher Clark. And what he says there, under the heading, the effect of Mitchell, is, in essence, Piemonte submits...
Was this before Denton or after Denton?
This is after Denton, just. He dealt with the case, and then after hearing oral submissions, Denton judgment was handed down, and so he then heard, had written submissions on it, and then gave his judgment. You'll see that in paragraph 38.
Mm-hmm.
And then in paragraph 39, his lordship sets out the arguments as to why Mitchell-Denton do not apply in the first part of that paragraph. And then picking it up in the second last sentence, his lordship says, there is thus, it is submitted, no reason to conclude that the Mitchell-Denton principles apply to an application under 13.3, or that promptness under 13.3 should be regarded as anything more than a factor. I disagree. Then says, in my judgment, the matter stands thus. So this is, in my submission, his decision. 13.3 requires an applicant to show that he has real prospects of a successful defence or some other good reason. If he does, the court's discretion is to be exercised in the light of all the circumstances and the overriding objective. The court must have regard to all the factors it considers relevant, of which promptness is both a mandatory and an important consideration. Since the overriding objective of the rules is to enable the court to deal with cases justly and at proportionate cost, and since under the new CPR 1.12F, the latter includes enforcing compliance with rules, etc., the considerations set out in 3.9 are to be taken into account. He then refers to the same, which I mentioned briefly, and Mitchell-Denton in another case. The fact that the court's judgment in Denton was reinforced by the fact that 3.9 was not reworded.
Is that the ratio of Hussein?
Yes. In my submission.
So why is everybody getting... Why are people not saying they're bound by the Court of Appeal?
Well, that is what we're saying.
And why are we not bound by it?
We submit that you are, but even if you're not, even if it isn't...
Should you not show us Hussein, if that's the governing authority? I mean, because that was the issue in Hussein, was it? I mean, I don't know. I haven't looked at it for a long time. And presumably we mentioned Hussein in Denton.
Yes. The important passage in Hussein is at page 43 of the transcript of the bundle, paragraph 30.
You see, Christopher Clark was in Hussein. Was did you say 43?
Yes, page 43 of the bundle, paragraph 30. Where Justice Chadwick says, I've referred to the provisions of 13.3, but there are, of course, other provisions of the civil procedure rules which are of relevance. First, there's the overriding objective to which the court must give effect. that requirement applies as much to the exercise of the power to set aside a default judgment as it does to the exercise of other powers. Second, there is by analogy the guidance given in 3.91, relief from sanctions, and in 39.3, setting aside judgment where a party has failed to attend a trial. And then he says, 32, 3.9 emphasises the need for the court to consider all the circumstances when deciding whether to relieve a party from any sanction. It may be said that those are matters to which the court will be bound to have regard, whether or not they were set out in 3.9 in deciding how best to give effect to the overriding objective. But in the context of this case, it's pertinent to draw attention to 5 of them, and then he sets out 5 particular factors which he considered to be important. So we would say that case is supportive of the way in which the court should approach this.
Yeah, but it's not binding authority. It's about adjourning a trial.
That's why I passed over it.
And he says by analogy. So it's not the binding authority on this point. But I see. Okay, good. Sorry.
So coming back, if I may, then to Piemonte, I've quoted paragraph 40. Now, as I understand it, Malone accepts that the correct approach to applications under 13.3 is set out in Piemonte, but says that...
I'm sorry to be difficult, but I realise now it's going to be difficult to deal with this case with a bundle of authorities without the proper reports, because I don't know from Denton whether Hussein was cited without seeing the report. It's going to be the same in other cases. Since we've got a proper determination we have to make as to what is binding authority and what is not, I absolutely need the proper report. So I'm afraid your solicitor's going to have to go away and do a proper job.
Of course. Well,
yeah.
Of course we will, and we should have done it already.
Yeah, I apologise. I hadn't realised it mattered, but it does matter.
Yes.
Because I was really handicapped looking at Hussein, having to work out what had been decided without seeing the head name.
Well, we'll certainly do that promptly.
Can you do it promptly? Yeah,
of course.
Thank you. Sorry.
No.
Back to Piemonte.
Yes, Piemonte, as I understand what's being suggested is that that the court should conduct a balancing exercise between 13.3 1A, B, and then 13.32, first of all, as setting aside default judgment under 13.3 is discretionary. The court should then make its decision in accordance with the overriding objective.
So where are you reading now?
Well, I'm summarising, I hope accurately, the respondent's skeleton argument at paragraph 4, which my own friend sets out their position. She says, I think the consideration of the overriding objective is likely to include the scrutiny of many of the same factors as would be considered under 3.9, and that the Denton test is a useful tool for this analysis, but that it's not a standalone test that must be satisfied after conducting the balancing exercise required by CPR 13.3. And she says that there is some support for that in paragraphs 36 and 126 of the judgment of Christopher Clark in Piemonte. With respect, that isn't, we would say, what Piemonte says. If your lordship goes to those paragraphs, Lord Justice Christopher Clark is conducting a balancing exercise, but it is between 13.31A and 2. In other words, he's looking at the prospect of success and the promptness in making the application. And that's what he's referring to as the delay in paragraph 36. At 34, first of all, he says, says subject to an important qualification. I'm just looking. Yes, at 34, subject to an important qualification, he says, I would accept this as a broad summary of the relevant principles. That's a reference to, forgive me, reference to the judgment in Piemonte, Mr. Justice Cook, I think. CPR 13 makes clear that the power to set aside is discretionary, that the conditions specified in 13.13(1)(a) or b are necessary, but not necessarily sufficient, stress those words, conditions for the exercise of the discretion. And 3, that the question as to whether the application has been made promptly is a mandatory and obviously therefore important consideration. It follows that a court may be entitled to refuse to set a judgment aside, even if the defendant shows a real prospect that he may or may not, or might succeed in his defence at trial. And so the delay being referred to there is, if I put it this way, the lack of promptness, the 13.2 factor, which he is referring to. And when one gets to paragraph 36, which my learned friend relies upon, where his lordship says the qualification is that it doesn't seem to me that the merits of any defence are ever irrelevant, when it does consider them, it may conclude they're little or no weight. The court is engaged in an exercise of weighing delay against merits, which will include considering the nature and extent of the delay, the reason and any justification for it, the strength of the supposed defence, and the justice of the case. The stronger the merits, the more likely it is that the court may be prepared to exercise its discretion to set aside. That's not to say that a real or even a good case in the merits will usually lead to the judgment being set aside, despite significant delay, since delay is now a much more potent factor than heretofore. If there's a marked and unjustified lack of promptness, that itself may now justify a refusal of relief, because the delay is a factor that outweighs the defendant's prospects. Now, what we would say is that the delay to which he is referring in that paragraph is the delay before an application is made to set aside judgment. So it is part of the balancing exercise required under 13.3. And indeed, the respondent relies upon, then goes on to rely upon paragraph 126 in the learned friend's skeleton, which is the concluding paragraph in which his lordship returns to this issue. Page 80 in your bundle. I don't regard Piedmont as having established the judge's refusal to set aside the default judgment or his grant of summary judgment on the managed claims were in error. Whilst in limited respects I found that there was a realistic prospect of establishing non-compliance, that is not sufficient to justify setting aside the judgment. In my view, the extent and nature and character of the delay alone afforded good grounds to refuse to set the judgment aside, even if the defence had a real prospect of success. And again, in my submission, that actually is a reference to the lack of promptness in making the application. And the reason I say that is because if you, I'm sorry to jump about in this judgment, but if you go to...
So where were you reading from?
I was reading from the concluding paragraph of his judgment, which is really coming back, relied upon by my learned friend, to suggest that what this judgment decides is that it's all a balancing exercise and that this isn't a separate analysis. And what I say is that the delay referred to in paragraph 1 to 6, the very last paragraph, which he rightly suggests, page 80. The delay referred to, in my view, the extent and character of the delay alone.
I mean, the trouble with this case is it wasn't argued fully with Denton having been decided. So you see bits of the judgment that look very much like they were written before they took into account Denton. Then Denton comes along and overlays it, and then you get a concluding paragraph. It's a rather unhelpful foundation, not because in any way it's wrong, but to analyse it like a deed when it came in those circumstances. I mean, it's broadly supportive of your case.
Yeah. Well,
we need to look at the other cases, and particularly the ones that are not supportive of your case. And hear what you say about those.
yes. Let me turn to Matthews, which is the judgment of
Which predates all of this.
yeah.
And wasn't cited anywhere? Wasn't cited in Piedmonte, wasn't cited in Hussein, wasn't cited in, Hussein's before, wasn't cited in Gentry, wasn't cited in Denton. Is that right?
No. Well,
No.
I'm perhaps jumping. I'm attempting to deal with the arguments that my learned friend I anticipate is going to make. And my submission is that
I mean, it's a bit odd, isn't it? Maybe it would be better to hear her first.
I'm in your lordship's hands. But our submission on Matthews would be that Lord Dyson was dealing with an entirely differently worded set of rules, and it's simply wrong to suggest, as my learned friend does, that the Trinidadian rules, the wording of the Trinidadian rules.
What's the essential difference?
Right. The rules in Trinidad are 13.3, same number, and 26.7 rather than 3.9. If you look at the authority, if you turn to paragraph 5 on page 29, part 13, can I pick it up at the bottom of halfway through paragraph 5. Part 12 contains rules in relation to default judgments. It provides that if requested by the claimant to do so, the court office must enter judgment if the defendant fails to enter an appearance and the defendant fails to file a defence. Part 13 deals with the setting aside or varying of default judgments. Rule 13.31 provides the court may set aside a judgment entered under 12 if the defendant has a realistic prospect of success in the claim, so that's the same. B, the defendant acted as soon as reasonably practicable when he found out that judgment had been entered against him. Now that is a materially different rule, we would say, from the CPR 13.3 in England and Wales, because it is a requirement that the defaulting party must establish that he acted as soon as reasonably practicable. So it's not something one just puts into the balance. It's a requirement that the defaulting party must establish. It is therefore, we would say, a significantly more onerous requirement than the one which applies to defaulting parties in England and Wales. And one can perhaps understand why Lord Dyson might conclude in particular circumstances of that case and the rules as they were drafted in the Trinidad and Tobago jurisdiction. But in those circumstances, the Trinidad equivalent of 13.3 is itself a self-contained provision. And similarly, and in fact with more force, Rule 26.7, the wording of which you will find at paragraph 7.
Where do we find our 13.3, just to compare it precisely?
13 the English 13.3.
Yeah. Well, we can look at it in Gentry and Miller, I suppose.
Yeah, that's what I'm going to do. It's
Court may set aside.
page 80, paragraph.
The form of words is the same. The court may set aside a judgment if.
Thank you. Page 86 has a helpful summary of the three rules. 13.3 may set aside or vary judgment if real prospect of success, and then 2, in considering whether to set aside or vary a judgment entered under 12, the matters to which the court must have regard include whether the party seeking to set aside the judgment made an application to do so promptly.
That's completely different.
Completely different. It's different because it's a requirement. That is what the defaulting party has to establish. Whereas in the English version, it's one of the factors to be taken into account, albeit obviously an important one since it's referred to specifically.
So in the English rule, the England and Wales rule, even if you're not prompt, you might still get judgment set aside.
Exactly.
Whereas in the Trinidadian rule, if you are not prompt, the court has no discretion to set it aside at all.
That's exactly right. And that's even more stark when one compares the other provision, which Leonard Friend suggests is the equivalent. If you go back, if you would, to Matthews, rule paragraph 7 sets out rule 26.7, which is, it's suggested, the equivalent of 3.9. And you'll see there that there are a whole raft of requirements which are necessary, which don't find their way remotely into 3.9, requirements that the defaulting party would need to satisfy the court that failure was not intentional, that there's a good explanation, the party has generally complied with other rules, and then in sub-rule 4, have regard to the interest of justice, whether the failure was due to the party or his attorney, whether it can be remedied within a reasonable time, and whether
Isn't all this reminiscent of the old 3.9? The old rule about relief from sanctions, which used to have a list of 9 things.
Yes, it did.
Is some of those things?
Well, so I haven't made a comparison.
I think we need to see the old rule, our old rule,
Yes.
please.
Yes, we'll find that. It certainly was a list of factors.
It was a list of things. I can't remember it, but we looked at it in Denton to see the derivation of the new 3.9 through the Jackson reports and so on.
Yes. Can we come back to that, perhaps?
Yeah. Okay.
And look at that. And there's another point which I need to make in relation to Matthews. In any event, of course, although decisions of the Privy Council are persuasive, they're not binding upon this court. And if they are inconsistent with the decision of a court which is binding on this court, then of course this court should prefer the decision which is binding. But in any event...
What do you say is binding here?
Piemonte and Gentry. I made the point already, and Your Lordship's going to hear from an own friend. There wasn't full argument, but it was a fairly well thought out.
Well, I mean you are going to have to just make that good, because we just need to think about the rules. Gentry was a case about CPR Part 30 something else, about adjourning trials, wasn't it?
It was both.
Well, I don't think it was both. It was a case about adjourning trials and the sanctions that arose for not attending a trial. That was what the facts of that case were about, I think. So if it's going to be binding, then we need to just look at what it actually decided. And but do you say that Matthews is actually decided this point? Actually, Matthews, there wasn't a default judgment in Matthews.
No, I was just going to go on to say that. In fact, the court was dealing with something entirely different, because in Matthews, the defendant hadn't filed a defence in time but the claimant would not agree to an extension of time. So what the judge was hearing was an application by the claimant for judgment in default, and at the same time an application by the defendant to extend time. So this wasn't, it hadn't reached that stage, so to speak. This wasn't an application to set aside a default judgment. And in any event, I say, the rules are different, at least from those rules which apply now.
Okay.
We'll look at the wording of 3.9 in due course. And if one just looks at all the requirements of the Trinidadian Rule 26.7, I do say that it's perhaps hardly surprising in that case that Lord Dyson took the view that there wasn't room for an additional layer, namely the additional rule to apply, because Rule 26.7 was a fairly self-contained and also quite onerous rule in itself for a defaulting party. Can I take your lordship to
I mean, I do think it's quite important to see the old Rule 3.9, because my recollection is that this is precisely what we were considering when the Jackson reforms gave rise to a new rule abrogating the old 3.9, which looked remarkably like this 26.7 and had a list of things you could take into account. You had to take into account. And Mitchell and Denton said this created a revolution, right? And there would be a new wind, because you had to, the two things mentioned in 3.9 were really important to the administration of justice. And that's what the Jackson report had effectively said. But there was a little wrinkle, because Jackson had himself suggested some amendment to the 3.9. I can't remember the precise chronology, but Jackson had himself suggested an amendment which was not implemented.
So I vaguely recall reading that somewhere. Yes.
Yeah. So we sort of, I mean, at some stage we're going to just have at least to be directed to where we find that history, because it is important if it's being said that this case is on point. I mean, I completely understand your point about the rules being different and that the rules are closed here, whereas our rules are open. And I completely understand the point about it not having decided anything, but it is the Privy Council, and it is Lord Dyson specifically, who was a party also to Denton.
Yeah.
So I would like to have it sort of bottomed out about how our rules got to the point they were at. I maybe explained it a bit in Denton itself.
So I'm sure that we can find the wording of the old rules. Would you give me a moment? Okay. And then a friend very helpfully tells me that if you look at paragraph, 32 of Hussain, that's the judgment of Lord Justice Chadwick, it's page 44, some of the factors, some of the checklist of 9 are set out in the paragraph which in fact I started to read and then skipped over those. So you've got 5 there, but we'll find them all.
Yeah, okay.
And now, can I take your lordship to Gentry just briefly?
Mm-hmm.
The relevant paragraphs are perhaps, for our purposes, begin at paragraph 23 on page 88. And paragraph 23 records, of course, that parties accepted that Denton did apply 13.3, and there's a reference there to the paragraphs to which I've taken your lordship already from Lord Justice Christopher Clark's judgment in Piemonte. And your lordship made the point, it seems to me equally clear, same tests are relevant to an application to set aside a judgment or order under Part 39.3, which is, of course, a judgment entered when a party doesn't attend trial. And then your Lordship went on. The first questions that arise, however, in dealing with an application to set aside are the express requirements of that rule, 13.3, and you set them out. And then, since the application is one for relief from sanctions, the Denton tests then come into play. The first test, as to whether there was a serious or significant breach, applies, not to the delay after the judgment was entered, but to the default in serving an acknowledgement that gave rise to the sanction of the default judgment in the first place. The second and third tests then follow, but the question of promptness in making the application arises both in considering the requirements of 13.32 and in considering all the circumstances under the third Denton stage. And then your Lordship, as your Lordship said just now, then looks at 39.3, and the wording of 39.3 can be found in paragraph 14 of this judgment, along with 3.9 and paragraph 16, actually, on page 87, where a party doesn't attend and the court gives judgment or makes an order against him. The party may apply for the judgment to be set aside, and then there are conditions attached to sub-rule 5, acted promptly, had a good reason, had a reasonable prospect of success. So, and going back to the judgment in Gentry at paragraph 25, I don't think that any different analysis applies under 39.3. The court must first consider the three mandatory requirements of 39.3 before considering the question of whether relief from sanctions is appropriate, applying the Denton test. Again, the sanction from which relief is sought is the order granted when the applicant failed to attend the trial, not the delay in applying to set aside the resulting judgment. The promptness of the application is a precondition under 39.35a and is considered as part of all the circumstances under the third Denton test. So the court in Gentry concludes that Denton applies equally to 39.3 as it should to 13.3. And that decision in relation to 39.3 has been...
Was there a default judgment? I can't... Or was it a 39.3 judgment?
I think it was a 39.3. It's both, I'm told. Thank you.
So why was that going on about 13.3 all the time?
Because it was both.
Why was it both?
Thank you.
It
I'm
was a
referred to
judgment.
paragraph 28.
This is where we need a head note.
I know.
So I see what was being said was that I see. So the 13.3 applied because it was a default judgment issued under 39, Part 39, because of non-attendance, not a default judgment issued because of the non-filing of a defence. No? Okay. What are the facts?
Forgive me. I remember that.
I know, because
It was both, in fact. There was a default judgment on liability, and then the trial which the defendant failed to attend was the quantum hearing.
right, that's
Thank you.
so that's why in paragraph 7 we see a Part 13 application, 13.3, and then it was.
Just picking up that decision as it refers to 39.3. decision, your Lordship's decision in that case, has been followed in the Court of Appeal case of Family Channel Limited and Fatima, which for once we do have the weekly law report copy of it. It begins at page 241. And in that case, if your Lordship turns to paragraph 43 on page 253, the Court refers to Gentry and Miller and Mitchell and Denton, and goes on. The three stages identified in Denton are well known. Under 3.9, the Court is required, the Court sets those out. In Gentry, Lord Justice Vose explained, and then he sets out your Lordship's point, which he set out in paragraph 25 of Gentry. Then at paragraph 47, CPR 39.3, 3 to 5 provide for a specific procedural remedy with its own self-contained code of applicable principles, albeit subject on the question of ultimate discretion to a consideration of CPR Rule 3.9, which reflects the overriding objective and the Denton principles. So that's an authority which supports the conclusion which your Lordship reached that the Denton principles apply to 39.3. And if my learned friend were right to say that Denton does not apply to 13.3, then we would have what I would submit as a bizarre situation of Denton applying, unless this case is wrongly decided and is not binding, that on 39.3 a different test applies to the one which applies under an application to set aside judgment under 13.3, which would be, in my submission, very curious indeed.
Okay.
My Lord, both my learned friend and I in our skeletons refer to a number of High Court authorities, and I don't know whether your Lordship is going to be assisted by my taking you through those in detail.
Why don't you see what Miss Ayres manages to make out of them?
Yes, I'm more than happy to do that. Can I just check there wasn't anything else I wanted to say before that? I was going to deal with the two High Court authorities on which she places reliance, but perhaps I can come back to that. Perhaps I could leave it there for now. Thank you very much.
Thank you. Yes, Miss Ayres. I mean, I just don't want you to be put off saying that I'm completely wrong in every particular, if that's your case.
I believe it's not a position I want to be in.
Doesn't matter whether you want to be in it or not. Unfortunately, that's your job. But I seriously don't want you to be stupidly deferential. If I'm wrong, right?
But
And I fully understand that Mr. Dias has explained in Technicolor why I'm wrong. And if he's right, then I will have to take account of it. So my mind is open.
thank you, Lordship. I think what hitting the nail on the head here, I think what the issue is what Gentry says.
Is what?
It is what Gentry says.
Yes. Well, now, not only Gentry, of course, it's also Fatima.
Yes, although if Gentry is wrongly decided, then Family Channel also is. Although I'm not sure.
I don't know what was decided in Fatima.
Yes, and that was specifically with 39.3. My submissions actually focus on the fact that the late entry of a defence, the late filing of defence, is quite a specific thing within the rules. So whether or not there's a different rule for a party not attending trial is potentially a different question for a different court on a different day.
I see that, But I think you've got to show that there isn't a read across, because courts of appeal have said there is. So you would have to show that the formulation was different. In other words, the closed loop that you say setting aside a default judgment is not the same, is not the same as the 39.
I think the reason it's not the same is twofold.
Right.
Firstly, that there is no mandatory time limit for filing a defence. And secondly, that the entry of default judgment is something quite special within the rules that is not, in my submission, an automatic sanction. And that's what I say would distinguish the issue of default judgment from that of party not attending a trial. So I would say that Family Channel actually doesn't really have any relevance to this case at all.
Right.
If I might just go back to Matthews, because it is obviously a cornerstone of what my submissions are. My learned friends made some points that the rules are different, so essentially therefore it's not relevant. Well, my submission is that the principles are the same. And in fact, the White Book itself says this. Page 441 of the 2023 White Book. It says of Matthews that although the decisions were made on the basis of the civil procedure rules of Trinidad and are not binding, the principles applied are likely to be equally applicable under the CPR. So what I want to look at specifically in Matthews starts at paragraph 12, which is on page 32 of the bundle. I see that my lady's looking at that reference. It's the 31.1.
No, I've got it. Thanks very much indeed.
Thank you. So paragraph 12, what Lord Dyson is addressing head on here is what has become known as the implied sanctions doctrine. And he says the claimant seeks to uphold the reasoning of the majority and in particular the notion of the implied sanction. And then what he does is he quite elegantly encapsulates what an implied sanction is in A to F. A party needs to take a procedural step. It can't do that because there's a mandatory time limit. The time limit's expired. Unless a rule states otherwise, they're disabled from taking the step. Being placed under that disability is an adverse consequence, which in colloquial parlance, a sanction, adverse consequence, and then F, that it is in fact a sanction. And then what he does at 14, on page 33, is Lord Dyson specifically says, I would reject these arguments. So what he's doing is he is explicitly rejecting the implied sanctions doctrine there.
I mean, you're going to have to help me with what the implied sanctions doctrine is. I saw that you'd put in a lovely academic article that seems to slag off the entire regime constructed by Denton, but is that what you're saying?
We can go to that article. It's probably the quickest way of summarising what it is. Although before we do that, I think it's a central pillar of my submissions is that actually a defence is special because there is no mandatory time limit for filing it, after which you need permission. So actually it's not even an implied sanctions case, this. The article is at tab 10 in the bundle. What Stuart Syme's doing in this article is running through the history of it, and at 207 he sets out that its origins actually trace to a case called Sayers and Clark Walker. That was a case about extending time for permission to appeal. And the reason that that line of authority is distinct from this is because, again, when extending time for permission to appeal, there is a mandatory deadline for filing for permission. The same is not true of a defence. Then what Mr. Syme does in the article is he goes through the history of how that case then started to proliferate other cases, essentially by stealth, applying a relief from sanctions framework to what became known as implied sanctions, i.e. where there's a mandatory deadline and the party can't take the step after that's expired. What I think is important to note, I mean, it's not an authority in the bundle, but is at 208, the third paragraph down, he talks about how the Court of Appeal in Sayers and Clark Walker was anxious to avoid a proliferation of judge-made checklists dealing with different aspects of civil procedure. Now, why that's important is because there were lots of different...
Sorry, I need to know where you are. Where are you reading?
208.
208, paragraph.
Third paragraph down starts the Court of Appeal. And here he's just still summarising the history of the implied sanctions doctrine, regime, whatever it's become known as. And the case that kicked that off, basically, was Sayers and Clark Walker. But what the court was focused on there was trying to provide coherence to a situation where there had been many different judge-made checklists.
So this was in 2002.
Yes.
This was long before the rules changed.
Yes, exactly. So this is the genesis of something that has persisted sort of in the background throughout the rules. And in my submission, it's something that certainly the courts in this country haven't yet dealt with head-on. And where it has been dealt with head-on was in Matthews. So fundamentally, the question is, where there's no express sanction, i.e. witness statements, if you don't file your witness statement, you can't rely on the oral evidence, that's an express sanction, versus you must file your particulars of claim within 14 days. It says nothing after that period, but if you don't, what is the test to apply?
Well, why is there not a sanction in the defence case? You don't file a defence, you can't rely on a defence.
It's going to sound very nerdy, but it's very interesting when you look at the rules. So I think what I would like to do is take the court to the rules.
Amazing. But they're not in the bundle, are they?
They are not. I do have copies of certain of them, but I was informed by your clerks that a copy of the 2023 White Book should be...
Well, I'll look at it online. What's the... which rules do you want to look at?
So we start at CPR 15.2.
I mean, I'm not quite sure we've got this implied sanction. So what you say, before we go to the rules,
Yeah.
you say there is a fundamental difference between a sanction which is expressly, between a consequence that is expressly stated in the rules and a consequence that is not.
Yes.
So a consequence that is expressly stated is you are debarred from defending if you don't file. You're debarred from serving a reply if you don't serve it within a particular time.
Yes, that is one. Reply is mandatory. I mean, quite a good example is you cannot contest jurisdiction unless you do it within Part 10 and Part 11.
But if there's no express sanction, you say that's different.
Yes, then that would be
That's an implied
is
sanction.
an implied sanction.
What this is all about is whether you can get an extension of time after it's filed and whether you apply the relief from sanctions doctrine after the date's expired.
It's a bit about that, but again, I say in this case, the defence is actually different because there is still no mandatory time limit after which you can't take the step. The thing that means you can't take the step is default judgment. And then there's a separate question of whether that procedure amounts to a sanction for CPR 3.9. It seems quite facile to take your lordships to 15.2.
No. 15 is absolutely critical.
Right. Because I think what a lot of these cases have done have assumed something without a forensic analysis of the rules. And
Well,
I think
in Denton, we said that the first step in any sanctions case is to identify. I mean, it's just worth looking at it because I think it's actually quite important.
yeah. Well, I think there's a really good place to look at that, actually.
This makes it clear that the
Yeah.
court's first task is to identify the failure to comply with any rule, practice, direction, or court order which has triggered the operation of the rule in the first place.
Exactly, triggered the operation of. What's inherent is it's automatic, and it is the rule that you breach that has to trigger the sanction. And actually, Your Lordship's reminded me there's a very recent case that I believe he was in at tab 23 of the bundle. It's in the second authority bundle. It's the case of CNM Estates.
Sorry, I haven't got a second authorities bundle.
If you're walking from the electronic one, it'll all be in the one place. I think it's just in paper.
Right, okay. Which case?
Tab 23, CNM Estates. And the only paragraph I want to look at in this is paragraph 42.
Okay, well, I do know about CNM Estates.
Because I believe Your Lordship was in it. And what I think was a really great reminder that was in this case is paragraph 42.
Hang on, let me just find it because I've got to get it up.
Sorry.
Have you got it?
Yeah, it's in the electronic bundle. It's at tab 23. You need to
It's not in
expand.
mine.
You need to expand the bit that says cases addressing interpretation of the CPR at the bottom.
Oh,
of the,
okay.
of the
Sorry.
thing.
It's very much in the
Okay.
weeds of the bundle. I'm sorry.
No, the
Okay,
bookmarks
anyway.
are squashed up.
I've got it twice now. Okay, paragraph 43.
42, it's page 496. It's a short but, in my estimation, a really important point. So whether relief from sanction should be granted must be determined in accordance with Denton. But before that approach comes into play, two prior questions must be considered. The first is whether a rule, practice, direction or court order imposes a sanction. The second is whether a party has failed to comply with the rule, practice, direction or court order in question.
Is that Lord Justice Males?
Yes.
Because he's in the minority in that case.
But I submit that the principle is exactly what's been overlooked in many of those cases. Because in order for there to, it's facile, in order for there to be need for relief from sanction, there has to first be a sanction.
I agree with you. Where I'm not sure I do agree with you is that Denton is limited to the case in which the sanction is provided for in the rule that you breached. Because I don't find that in Rule 3.9.
And that may be the case, but again, I would single out defence and the entirety of the default judgment regime as being quite special in the context of the CPR. And because there is a specific test set out expressly in 13.3, then in those quite specific circumstances, that is why 3.9 doesn't apply.
Sorry, you're going to have to take that a bit more slowly for me, I'm afraid. Just say that more slowly.
So I think Your Lordship's point is Denton doesn't say that 3.9 only applies to express sanctions of the type that it considers. It can apply to other circumstances. Setting aside judgment after trial might be one. But what is different are the rules about defences and the rules about entering default judgment. Because entering default judgment is quite a special and particular thing within the rules that is not mirrored elsewhere. And that's why I say it doesn't apply. And actually, if I might just...
Let's look at the rules.
Yeah, that's where I was going, wasn't it?
Yes. Good place.
So 15.2. A defendant who wishes to defend all or part of a claim must file a defence. Uncontroversial.
Must.
Not
Must.
must. Yes.
So if you wanted, sorry, the point I made to you, I made badly. That what you are, what you're trying to get is permission to defend the case, because you can't defend the case under 15.2 unless you file a defence. So you've not filed a defence, and you can't defend the case unless you do, So that is one of the sanctions, not being able to defend the case.
Yes, but there's no time limit within which you have to do that, and that's at 15.4.
Yes.
And it is worded quite differently to particulars of claim form. It says the general rule for the period for filing a defence is 40
The reason it says general rule is because it's subject to exceptions. It's not saying that it's not a rule. They're there in sub-rule 2. You're saying that the words general rule mean that it's not really a rule. You don't really have to file your defence 14 days after the particular claim.
Well, not in that sense, but the rules do envisage that you can file a defence up until any point at which default judgment is entered.
I agree.
And for example, 1511 expressly envisaged the situation where 6 months have passed after the time for entering default.
Well, 1511 is a long stop provision.
Yes, but it expressly envisages a situation where a defence hasn't been filed within 14 or 21 days. And what the High Court decisions, which I can take you to after going through the rules, say is you can file a defence at any point up until default judgment is entered.
Well, you can. Right.
And you don't need permission to do that.
And you don't need permission.
Yeah, and that's the key point. Because if you can do that...
But also, the claimant can get judgment.
Yeah, but that's
and
not...
then you can't.
Yes, and that's not a sanction. So up until the point when there's no default judgment, the adverse consequence is the claimant might apply for default judgment.
Sorry, what is not a sanction?
The fact that after the expiry of those 14 or 28 days, the claimant might apply under Part 12 for default judgment.
No, it's not, but that's not what I suggested. The point is this. Sorry, I'm just writing that down. The rules provide that if you want to defend the claim, you must file a defence within the time limited in 15.4. None of the exceptions in 15.4 apply in this case, right? You agree?
Yes.
None of the other time limits.
No.
Summary judgment, strikeout applications, all that stuff.
Yeah.
Right, so you must file a defence within 14 days of the acknowledgement of service, I think. Is that right?
Yes, or the particulars. 28 days if you file an acknowledgement.
Okay, well, anyway, it doesn't matter. Right. And then you are at risk. If you fail, there is no immediate sanction. You can defend the claim at any stage you validly file a defence. They claimant can also enter judgment. And when the defendant enters judgment, which they are entitled to do, you can no longer file a defence, and therefore you can no longer defend the claim without relief from sanctions.
So that is, I agree with absolutely everything up to that last point. That is where I would say, no, it's not a relief.
So the entering of a default judgment is not crystallising the position that you have breached a time limit and therefore become debarred from being able to defend the claim and need the court's permission to defend it.
I agree with all of that, but what you do is you apply under 13.3.
Yes, but 13.3 is not exclusive.
No.
It says we consider things including X and Y.
Absolutely. And my position is simply that the discretion under 13.3 is unfettered. And whether that includes or not some consideration of Denton as a framework idea or the Denton ethos of ensuring compliance with rules and practice directions, that's absolutely fine. What I say is it's not just Denton. It's not 13.3.
Well, Denton is all the circumstances, so...
Well, it's an interesting point because obviously when Denton first came out, there was a period of time where applications under Denton were a lot less likely to succeed than applications under the overriding objective. And for example, the in-time applications for extension of time out-of-time applications for extension of time. So there is a difference, even though they do consider all the circumstances. Now, there's less of a gulf between them, and they do both consider all the circumstances. But I think we have to treat this appeal on the basis that Denton applies a more rigorous standard than the overriding objective, because otherwise then there'd be no point in the appeal.
Denton, I mean, as Mr. Counsel submitted, Denton is important because of the two things to which you have to have particular regard. And I can't recite them, I'm afraid. You haven't got them sitting looking at me. But the two things are proportionate litigation and compliance with the rules.
Mm-hmm.
And that's the reason why you don't any longer get relief from sanctions just because you ask, which you used to.
I think there's a distinction there between whether, has the overriding objective changed? Has the overriding objective become stricter because of the Denton approach? And I would say yes, like it should have done. But there is still no need to apply a separate test, the 3.9 test, in circumstances where it doesn't apply, because that should already be dealt with under the overriding objective. So I go back to my point of that if there is no sanction, why apply a test that was crafted specifically for relief from sanction? And why it's different is because of Part 12, which the Lordships referred to, the rule is triggered by. What is blindingly different here is how Part 12 operates. It's also, I think, a distinguishing feature of the Part 12, Part 13 regime. It's at page 441 of the White Book, and the note to 13.1 sort of talks about how there's no judicial scrutiny of that process of obtaining default judgment, and there's no provision for leave to apply to appeal. And that's why a separate procedure is needed, that there's a reason why it's different.
Sorry, I don't want to get, you're going quite quickly, skipping over some of these rules. What you're talking about in relation to Part 12 is the automatic process for getting default judgments using a request for judgment.
Yes.
That's not the only way you can get a default judgment, you can apply for it.
Yeah.
And the automatic provisions in Rule 12 do say that you won't get default judgment automatically, even if it's a regular default judgment. If there is a defence on the file.
Yes. Yeah.
But that's not talking about what happens if you apply.
No.
It's talking about it's only talking about. So you need to be a bit careful with wide statements saying that everything's completely different, because it's not as simple as that.
No, it's not as simple as that, but I think it does also highlight the point even more that whether or not default judgment can be obtained is very far from being an automatic sanction. It is a self-contained process, whether that is by request or by application. It's not a sanction that applies automatically. And
It's not automatic because someone's got to ask for it. But
Yes.
why isn't it a sanction for failure to file a defence? Isn't that what it is?
because there's no mandatory time limit in the rules.
Well, it doesn't matter if there's a time limit. It's still a sanction for failing to file a defence. At the date that you're taking the automatic example, you're a claimant, you're not aware of a defence, you file a request for default judgment. What the court does, that's what Rule 12 says, is it looks at it on the day it's considering the request for judgment and asks, is there a defence on the file, which the claimant may not know about, because it may have come in that morning, and if that's what's happened, it won't automatically enter the default judgment.
Yeah.
But still a sanction for failing to file a defence. It isn't. You're right that you can avoid it being entered as a defendant by filing a defence out of time. That's true. But why isn't it still a sanction for failing to file a defence?
When you say it, Your Lordship, are you referring
I mean, the
to
default judgment.
a default judgment? Yeah.
Because I understand your submission. Your submission is that a judgment entered, a default judgment, you say, is not a sanction at all, and therefore Rule 3.9 doesn't apply to it, therefore Denton doesn't apply to it. That's your submission.
Yes.
And the point you're making is it's not a sanction for failing to file a defence within the time limit. And I understand the point you're making. The point you're making is that the way Rule 12 is now constructed, actually it gives a bit of leeway even if you're outside the time limit. And you're right about that. It's more complicated than that, but you're right about that up to a point. But what I don't understand is why that means the default judgment is still not a sanction for failing to file a defence. It may not be a sanction for failing to file a defence within the time limit, because actually you can file it after the time limit and still avoid it. But it is a sanction for failing to file it, which is what you're supposed to do if you want to defend. See Rule 15, and we'll go right back to the beginning again.
Again, this, I know it's quite a forensic argument, but it goes, I think there's two ways of using the word sanction. Clearly it is an adverse consequence as a result of not filing the defence, but sanction as defined in Denton is, as we've seen, failure to comply with the rule that has triggered the operation of it. Nothing has triggered whether a claimant decides whether or not to enter.
Isn't sanction as defined in Denton? What Denton was talking about is how do you apply Rule 3.9,
Yes.
which says it's a sanction for failure to comply with something.
Yes. Yeah. But it's a sanction for failing to comply with the rule that has triggered the sanction.
Why does it say that? It doesn't say that. The only place that you find that is in the Privy Council in Matthew, and the only basis for it is because they read CPR as if it was the same as the rules in Trinidad, which they're not.
Well, on that point, I mean, I started to address it at the beginning, but the fact that the rules are different, the principle is the same, I say, and the principle is that why should a situation that doesn't fall within 3.9, I mean, it's the wording of 3.9 itself that defines what a sanction is, and that is what I say Part 12 default judgment doesn't fall within.
Well, the wording of 3.9 is relief from any sanction imposed for a failure to comply with any rule. It doesn't say any sanction automatically imposed.
No.
It's just any sanction imposed for failure. And my Lord's question is, why is a default judgment obtained in the complex provisions of Part 12, because you didn't file a defence, not a sanction imposed for a failure to comply with Part 12.2 that says you must file a defence if you want to defend?
Because it's not a sanction imposed by the rule.
It doesn't say it has to be a sanction imposed by the rules. It says it's a sanction imposed for a failure to comply with the rules.
I mean, I take your Lordship's point, but what it has aimed at and what the case law that crafted it was aiming at were sanctions that were triggered. I mean, they were triggered expressly.
I mean, you can't, I'm sorry to say, you can't get away with what it was aimed at without saying why it was aimed at, because some would say that the whole ethos of the new regime of 3.9 that was all to do with Jackson and following up on the Wolf reforms was to make it much more difficult for people who don't comply with the rules. And so why would we exclude from people who don't comply with the rules people who don't file defences in accordance with the rules? Because that is the absolutely preeminently first step of defending a case. And I mean, one doesn't want to personalise this, but your client's lackadaisical attitude to the rules is precisely what Denton was dealing with and Mitchell was dealing with.
No, absolutely, and I agree with all of that, but I think there is still a difference between applying the Denton ethos to the overriding objective and just applying the Denton test.
I mean, I think that the high point of your case, if I may say so, is the first instance decisions in Cunicio and Mr. Dias's case. I can't remember the name. So you probably ought to show us why they say that this is the right approach.
Sure. If we start with, I think we'll link Cunico, but
Cunico, sorry.
No, I mean I'm probably wrong about that.
No, you're right. I'm wrong.
The thing to be said about this case, first of all, is that Rule 12.31 has changed after this case. It changed on 6th of April 2020 to reflect essentially what was decided in this case.
Sorry, 12.31
Yes.
has changed.
Yes.
Has it? Yes. Immaterially?
Yeah. Sorry, did you say immaterial? Materially. Materially, certainly.
Materially
yes.
changed.
Yes. The change was that I can take you to both rules actually.
12.31 now says the claimant may obtain judgment in default of an acknowledgement of service only if the defendant has not filed either an acknowledgement or a defence and the relevant time for doing so has expired.
And that bit before the relevant time for expired that you just read out is what's been inserted.
Right.
So prior to that, it was uncertain as to whether a defendant could still file an acknowledgement or a defence just before a default judgment application and whether that would be valid or not. What the 2020 amendment does, it makes clear that a late filed defence prior to default judgment being entered is valid. And I say that again backs up the argument that prior to default judgment being entered, there can be no question of a sanction having been imposed.
Yeah.
So in Cunico, we start at paragraph, it's at tab 7, starts at 116. Sorry, 112. And it's 116 that I'd like to take your lordship in relation to. Paragraph 12. On the face of things, Mr. Daskalakis is therefore not entitled to challenge jurisdiction unless he obtains respective extension of time and or relief from sanctions. But that is or may be a separate question to whether his late filed acknowledgement of service precludes any judgment in default. 13, that issue, i.e. whether an acknowledgement of service filed late but before a request for application for judgment in default under 12.13.1 precludes the grant of such judgment, is an important issue of principle, subject to conflicting first instance decisions. Then he goes to set out the different meanings that were live at that time, which the amendment has now resolved. Paragraph 15, he says, halfway down the paragraph, which meaning is correct, will also define what sanctions, express or implied, arise under the civil procedure rules for the filing of an acknowledgement of service late, but prior to any request or application. So he's saying whether meaning 1, 2 or 3 in paragraph 14 is correct, determines whether and what sanctions, express or implied, apply.
No, but this was the old one.
Yes. So what the amendment did was it enshrined in the rules the first meaning.
Right.
In this case, the judge only had to decide that the third meaning was incorrect to dispose of the claim. So he didn't decide as between the first and second meanings. But his reasoning starts at 32. It's on page 120. He's talking about a case of Mr. Justice Liam was Flow, who had referred to a late acknowledgement being a nullity. It starts sort of 4 lines down. His references to a late acknowledgement being a nullity are the use of language that have had an influence in some of the default judgment cases. He then says, can be set aside by the court, ceases to have an effect, and in law is thereupon treated as a nullity. That is what setting something aside means. But if Mr. Justice Flo meant to suggest that an acknowledgement of service is a nullity when filed late, prior to being set aside, and whether or not it is ever set aside, then with respect I cannot agree. So really there he's just finding that a late filed acknowledgement of service, and I would say the same is for a late filed defence, is not a nullity, is valid. He then goes on to say at 34, page 121, there's a clear and important difference between firstly whether some effect or consequence obtains under the CPR only upon some step being taken in timely fashion, and secondly whether a step not taken in timely fashion may be set aside, undoing the effect or consequence or otherwise that it would have had. I say that's again relevant to defences because as drafted there's no mandatory time limit for filing one. And then his conclusions are at over the page starting at 38, halfway down that paragraph 38.
The form of 12.3 recited at paragraph 35 is the same as the current form.
It's not, it's slightly different.
The critical difference, I think, is the reference to the current form in the beginning of the language where it says, at the date on which judgment is entered.
Yeah.
That's the new thing. That wasn't
Sorry,
there.
at the date.
Yes, it's in the sub. It's before the A and B part. It's in the introductory language. The claimant may obtain judgment in default of acknowledgement of service, and then only if. But then in the current rule, as it now is, it says at the date on which judgment is entered, and that language wasn't there before.
So on legislation.gov, they've got the old one.
Okay.
It's only 3 years old.
Right, anyway, good.
Sorry,
as long as I know, it's fine. Yeah.
So sorry, then I was taking you to paragraph 38. Halfway down the paragraph, 7 lines down, he starts, where application is made to set aside default judgment as a matter of discretion under 13.3, on the basis that there is a real prospect of success for a defence on the merits or other good reason, the question arises whether that amounts to seeking relief from the availability of judgment under 12.3 as a sanction for the defendant's original procedural default. 39, he says, if unconstrained by authority, I would have said it does not, because the availability of a judgment under Part 12 carries with it the availability of an order under Part 13 setting such judgment aside. And then a few lines further on, I mean that whole paragraph's relevant, but really I want to focus on then he says, in the latter respect, the discretion is unfettered, except if this be a fetter, 13.3.2 enjoins the court to consider as one relevant factor whether the application to set aside is made promptly. To make an application to set aside under 13.3, accepting and seeking to discharge that burden, to my mind, is to accept and operate under the CPI sanction for the original procedural default, not to ask for relief from it. And now I think this next bit addresses your Lordship's point about applying for relief from sanction for a late filed defence. Because then what he says is, the application that would involve relief from sanctions in the arena in which 13.3 also operates would be an application after default judgment had been entered at the time regularly for an extension of time for filing an acknowledgement of service or defence, whereby retrospectively to undo the basis for that judgment so as then to require the judgment to be set aside under the mandatory provisions. So I found that somewhat complicated to understand when I first looked at it, but I've come round to thinking that it's potentially right. He's saying...
Only potentially.
Well, I don't think it. For the purpose of this appeal,
I asked the question, so what?
I think the so what answer is you can either apply for relief from sanctions for your late filed defence for which default judgment was entered and which may be a sanction. And then what you're doing is you're extending time. So the court then orders actually your defence was filed in time. So then the mandatory provisions of 13.2 kick in to automatically set the defence aside. You can do that. Say, for example, if you had no prospects of success or you want to contest jurisdiction, that's the route you go down. Or you apply in the usual way to set aside under the discretionary provisions. So you're not seeking relief, you know it's late, but you're saying apply 13.3, apply the overriding objective to that test, and then it can be set aside under that.
That, I mean, just to say there are alternatives is ridiculous. I mean, you've got to set aside the judgment if there's a judgment. You may have to get permission to file the defence as well.
Yes, but in either
Once you've set aside the judgment, then you'll be given directions to file a defence. I mean, this is just overcomplicating the whole thing in order to, it seems to me anyway, to reach an outcome. You see what he then says. He says the contrary view, but he doesn't say what the contrary view was, whether it's to that last sentence or to the bit before. Presumably it's the bit before in paragraph 38.
Yeah.
What, as I understand he's trying to do is to say that because there is a regime in which you can apply to unwind a default judgment, that's not a relief from sanction, which I must say, I'm bound to say at the moment, I don't find a very attractive way of looking at it.
It's a reason why he's saying that, yes, because there's a regime, then that's a self-contained thing and should be applied. I don't say that because clearly it's not self-contained, because there is a discretion that has to be informed by something. But I say it's formed by the overriding objective, of which Denton can form a part. But it is not the only test to be applied because it's not a sanctioned situation. I might just address the court on the issue of whether Regione Piemonte is obiter or not. As I know, you spent some time with my learned friend on this issue. I think the first thing to note about that case is that it was a permission application.
It was
an application for permission to appeal.
So you're not going on in this case at the moment, or you're coming back to it?
Well, no, we might as well finish the next couple of paragraphs. It is 40. He talks about the contrary view being expressed, but he says it's obiter.
Well, it's amazing. It's an amazing dismissal of two Court of Appeal authorities and two first instance authorities, all as obiter.
I accept he's very brief on why it's obiter. The
and then he says there's no authority binding me, so I do what I want.
No, I accept that. The better explanation of why it's obiter is in PXC. And Judge Dias actually goes in to examine why it's obiter.
Yes, he does that, has that...
yeah, I read this and was looking for where's the reasoning for it being obiter.
Yeah.
And then 41, as you've already mentioned, Your Lordship, there's no authority binding on me.
I mean, you know, if you were going to say that he's right, that it's obiter, you're going to have to show me the rules about what obiter is, because certainly as far as Gentry is concerned, I'm not convinced the decision in Gentry is, as insofar as it states the law, is obiter. So you just have to show me why it is.
So in, if we start with Piemonte.
Yes, I mean Piemonte, for the reasons I gave earlier, seems to be a very difficult decision to understand what it is exactly doing. Because it seems to have tried to interweave Denton after the argument and probably after some of it was written.
Yes, it's a difficult decision.
But no doubt you'll be able to show me what it actually decided, anyway.
I think if we go to Piemonte, terms of it being obiter, the reason that Judge Dias gives for it being obiter is that the application or not of Denton and Mitchell made no difference to the outcome of the appeal.
The what?
The whether or not Denton applies, and if so how, made no difference to the outcome of the appeal. Because the judge's decision
That's
was
not the
upheld.
question, though.
Pardon me, Lordship.
That's not the right question. The question is whether it formed part of the court's essential reasoning.
And I say it didn't, because what the court concluded at paragraph 126 in Piemonte
You
is
say
that
it didn't because of paragraph 126.
yes.
Let's have a look at 126.
Again, I accept again that it is somewhat of a difficult authority because the conclusion is so briefly stated after such a relatively long judgment. But what the court's doing in 126 is upholding the judge's view that, 4 lines down, the extent and character of the delay alone afforded, in this case, good grounds to refuse the judgment, to refuse to set aside the judgment, even if the defence had a real prospect of success. And then at the end, the judge was entitled to take the view that there was no real prospect of Piedmont deciding, or at any rate, none with a sufficient degree of conviction to justify setting aside the default judgment.
Yes, but why is that? I mean, that's fine. That's what he decided. But did he not, as part of that reasoning, say that Denton applied to the process? And he's saying, but in this case, the essential part of the reasoning is the provisions of 13.3 and the way they apply.
Mm.
But he didn't say, I'm not taking Denton into account. He said, I have to take Denton into account earlier. He said, I disagree. Those are the words in paragraph 40, whatever.
No, he did, but then that didn't form part of his...
But it is part of the essential reasoning, isn't it?
Well, 2 points to make on that. One, in my submission, I don't mind whether Piemonte is binding or not, because in my submission, what it says is right anyway. But there is...
What does it say that's right? That Denton applies to setting aside a judgment?
That the overriding objective applies to setting aside a default judgment, and as part of that process, 3.9 factors will be relevant. And that's fine.
So why are we having this argument?
Well, the final part of my submissions on this appeal is it makes no difference, really, to the outcome of, especially what Master Thornett weighed up. But what my learned friends are contending for is the test is 13.3, then Denton. And that's what I say is wrong, because Piemonte doesn't say that. And that is why, for me, Gentry is the problematic authority, because that is, in my submission, the only Court of Appeal authority that suggests that that is the test.
You just have to show me why this case doesn't say that quickly.
Yeah, it's at paragraph...
because everybody seems to have interpreted it as saying that.
yeah, paragraph 36. Bottom of 59. What I say is right here is the court is engaged in an exercise of weighing delay against merits, which will include considering the nature and extent of the delay, the reason for any justification for it, the strength of the disposed offence, and the justice of the case. Over the page, stronger the merits, the more likely it is that the court may be prepared to exercise its discretion to set aside a default judgment. And then he talks about promptness. He also talks about, at the end of that paragraph, how the climate has changed with the introduction of the CPR, and stop court setting aside a judgment after 7.5 years. So that I say is all right. And then it's paragraph 40.
Well, 38.
Yeah. That, I mean, that whole section, I think paragraph 40 sort of summarises the above paragraphs.
And he says, submits that the Mitchell-Denton principles do not apply to an application to set aside a judgment. There's no reason to conclude that they apply. I disagree.
Yes, and I don't disagree that they may be relevant in the mix of the overriding objective.
Well, I mean, this is a Court of Appeal authority. They're saying they apply
Yes.
after reasoned argument.
No, but the way they apply is then set out in paragraph 40. So the matter stands thus: 13.3 requires an applicant to show that he has a real prospect of a successful defence or some other good reason. If he does, the court's discretion is to be exercised in light of all the circumstances and the overriding objective.
Well, that's just a shorthand for Denton, I suppose.
Well, I think that's the nub of, that's an important question. Has Denton... I don't think the Denton test is the same as the test under the overriding objective, because then there would be no reason for a distinction between applying the overriding objective to in-time applications.
Yes, but this is saying that Denton applies in terms, isn't it? I mean, and I'm not being silly with you. I mean,
No.
it is submitted, no reason to conclude that Mitchell and Denton principles apply to an application under 13.3 or the promptness under 13.3 should be regarded as anything more than a factor. I disagree. So he says there is reason to conclude that Denton principles apply to an application under 13.3. And then he summarises it by saying, light of all the circumstances of the overriding objective. But he's said expressly as a matter of law that in his judgment the Denton principles apply. And then he concludes by saying, well, what's really important here is 13.3, and I think the judge is okay. I mean, what I don't understand is how you or any of the other learned judges can just dismiss this as being so irrelevant.
Well, Your Lordship, in my special argument, I rely on this.
No, but I don't see what the difference is between, in your mind, between Denton and, the summary that he gives here, which is just a short summary.
Because here he says the discretion under 13.3 is informed by the overriding objective. And what the appellants contend for is it's informed exclusively by Denton. And the two are different.
Well, of course they're slightly different, but this is an inaccurate summary, that's all. He said Denton applies, and then he said, he summarised it inelegantly, that's all.
Well, I draw your attention to the rest of the paragraph as well, where he talks about how the court must have regard to all the factors it considers relevant.
But that's all the circumstances, which is Denton 3. I mean, what you're, if I may say so, I feel anyway, is sort of dismissing is the importance of the rule itself, which says that you must have regard the need for litigation to be conducted efficiently and at proportionate cost, overriding objective, and to enforce compliance with the rules. And the words in all the circumstances are to be found in 3.91. And, you can say it's different, but anyway, okay, I get the submission.
No, absolutely. In my submission, it risks turning everything into Denton, when there is a more general discretion under the CPR, which actually is the discretion that informs many of the decisions, the overriding objective.
The reason why Denton is so important is because of the bits that were put into 3.9, which are different from the old 3.9, which was a load of factors you could consider. But 3.9 says, in particular, having regard at every stage in litigation, that it has to be conducted efficiently and the rules have to be complied with. And that was new. And if we were to say, I mean, if the head and deputy head of civil justice were to say, no, you don't have to take that into account at every stage of when people break the rules. I know you sort of sideline Denton by saying, well, we can't have Denton everywhere. I mean, that's stupid. That would be terrible. But I don't think there is a difference, actually, between what you're saying, because you're sensibly admitting that the overriding objective and the need to comply with rules is critical, and Denton.
And I agree.
No, but you've told me they're different, because you say I don't want to go on about it, but you say that paragraph in Piedmonte is saying something different from Denton, and that's the bit I'm balking at.
Saying something different from Denton.
Yes. You said that sentence and the rest of the paragraph, I can't remember the number. You can get it out.
40.
Gentry, I think I'm saying it's saying something different to Gentry. But that may well be what your lordship disagrees with me on.
No, it's not. I don't disagree with you on anything. I'm just trying to understand what you're saying. I mean, we look at 40, and you said the reason why the Denton actually doesn't apply, despite the fact that he's just said it is because he says the discretion must be exercised in the light of all the circumstances and the overriding objective. And you said, and that's different from Denton.
Yes, the overriding objective test is different to the Denton test. Yes.
Right. What is the overriding objective?
An unfettered discretion, taking into account the factors of section 1, 2 of the rules. And it's the fetter on the discretion of structuring it in the Denton way that I say that's not what paragraph 40 says. Paragraph 40 says it's a broad, unfettered direct discretion, of which 3.9 factors might be relevant.
Okay.
Whereas what I contrast that with is Gentry, where the approach is very obviously 13.3.1 first, then sequentially apply Denton. So two different tests. So don't apply the overriding objective, but apply Denton. And that's what the appellants are saying the correct test is. And there is, for example, an obvious reason why that's wrong when you look at the treatment of merits. Because in 13.3, the treatment of merits is upfront and central, whereas in Denton, the body of case law says that the merits are of little or no relevance.
Which case law?
In fact, it's a case relied on by the appellants. It's at tab 13. It's the Supreme Court Prince Abdulaziz case. And in fact, the point was raised before Master Thornett as well. And the appellant relied on this case in the underlying hearing as well.
Can you just show me where Prince Abdulaziz says relevantly that the merits are irrelevant in this context?
So, well, it was in the context of procedural decisions. It's at page 276, paragraph 30.
It's a completely different procedural decision there, isn't it?
It is, yes. But that's...
I mean, this was a case about disclosure. It's an appeal from me, actually. I was upheld.
But that partly...
So could you just give me the reference again? Because my page 276 doesn't have...
Sorry, 267.
267, right, there we go.
paragraph 30 and 31.
Thank you. Thank you.
Yeah.
It's not a case I rely on, but it's a case that the appellants relied on in the hearing below to say that the merits aren't relevant to a Denton analysis.
Sorry, where does it say that?
The first sentence of 30, hard to see why the strength of either party's case should at least normally affect the nature and the enforcement of those directions. Further down, it would be thoroughly undesirable if every time the court was considering the imposition or enforcement of a sanction, it could be faced with the exercise of assessing the strength of the parties' respective cases.
No, but it's a completely different. I mean, it's completely misunderstood. Paragraph 29, in my view, the strength of a party's case on the ultimate merits of the proceedings is generally irrelevant when it comes to case management issues of the sort which were the subject of those decisions. And those were about whether they should be forced to sign a disclosure statement. I mean, of course, the strength of the party's case has got nothing to do, once you've got permission to defend on a summary judgment and the case is, it's a bit like CNM Estates. The point we were making in CNM Estates is you can't take into account in a regular application where there's no extreme delay, permission to amend, whether the case is strong or not strong. If it's a pleadable, arguable case, then you're entitled to run it in this jurisdiction. The same with this. This is not saying anything about Denton's applicability to default judgment.
No, and I agree. As I say, it's not a case that I relied on, and indeed the master found difficulty with it. But what it does show is the difficulty of importing one body of case law relating to relief from sanctions for procedural defects, for procedural defaults, for exactly the sorts of scenarios you pointed out.
You need to explain that a bit more. I mean, the 13.3 says there are two things you need to take into account. One, have you got a proper defence? And two, how long have you delayed? It doesn't say that you need to look at the length. You need to look at the seriousness of the breach, the reasons why you were late, or other court users, or the need to comply with rules. Why should you not overlay other court users, need to comply with rules, seriousness of the breach, onto the actual amount of delay and the possibility, the viability of the defence?
So two things I would say on that. One, those things should be dealt with an unfettered discretion under the overriding objective. In any event, that is all the circumstances. And two, if the rule had wanted to import 3.9 into it, in my submission it would have said so.
Well, it wasn't. It couldn't possibly have done because it's much older than 3.9. 3.9 is new.
Yes, although there are, so 3.6, for example, does expressly import 3.9 into itself.
Does it?
On page 116 of the White Book.
Mm-hmm. Yeah, I see that.
4. So, I mean,
That's a good point.
the most obvious point is if it wanted it imported, it would have said so.
Okay.
And there are plenty of other authorities that say that if the draftsman had wanted it to be imported, it should be in there. That the authority that's before you is Totty and Snowden. I won't take you to it.
Which one?
Totty and Snowden. It was a case where the court was deciding whether the strict regime for late service of the claim form also applied to particulars of claim. And essentially they found, well, no, obviously not, because if the draftsman had wanted it to be imported, they would have said so.
Okay.
So there are good reasons for why it should be an unfettered discretion rather than one informed simply by Denton, but I think I probably need to look at Gentry head on, because that is the case that says it's 13.3 then Denton,
Yeah.
and that's at paragraph. Bear with me. 24. And the appellants rely on this paragraph. They say the first questions that arise are 13.3, the express requirements of the rule. And then later in that paragraph, what is said is, since the application is one for relief from sanctions, the Denton tests come into play. And so this is the case that says it's 13.3, then Denton. All I am saying is it's 13.3, then overriding objective, of which the Denton factors may well have some relevance.
So you say what's wrong here?
That the discretion is informed exclusively by the Denton test, whereas it should be an unfettered discretion, which is what I say was decided in Piedmonte, even though the Denton factors might be relevant.
I'm sorry, Miss Ayres, I lost the paragraph of Gentry you're talking
24,
about. 24, thank you.
page 88. And where I say that judgment struggles is its classification of setting aside default judgment as an application for relief from sanctions. It's not. Whether or not it's treated analogously is another point. But it is not an application for relief from sanctions. It's an application under 13.3, which is informed by an unfettered discretion. So why I have to say that Gentry isn't binding is I have to say that the point was not fully argued before the court. The only case before the court on that issue, well in this version anyway, is Piedmonte.
Sorry, I mean, you say it's not fully argued, therefore it's not binding. Don't understand that.
Well,
You're
it was
going to have to show me some authority that when the court sets out the law applicable to the case before it, I mean, is it per incuriam, or why do you say it's not binding?
well, it can't be per incuriam because there's no other binding decision that it should have
Right?
followed. Well, unless Piemonte is binding, in which case that's fine. But
You
I
say it's not binding as opposed to being obiter dictum.
Sorry, as to Piemonte.
No, you say Gentry
Ah,
is not binding, not that it's obiter.
well, I think if it is obiter, then I would have to say it's not binding.
No, I'm asking what your submission is.
Well, I would say it's obiter because it seems, I mean, your lordship will know far better than I as he was in it, but it seems from a reading of it that essentially everyone agreed that that was the position, so the court didn't apply its mind to the question. It therefore went with what it was told was the agreed position. So therefore, I would say it was obiter because it wasn't part of the decided ratio of the case.
Yeah, okay.
And in any event, I say that if it's relying on Piemonte, I think your lordship disagrees with me, but I would suggest that the two-stage approach that is proposed in Gentry is not quite what was said at paragraph 40 of Piemonte.
Okay.
Because quite clearly on the face of Piemonte, the discretion is the overriding objective. And on the face of Gentry, it's the Denton test. And that's why I say they're inconsistent. Now, whether or not in practice that makes any difference is another question, but that seems to be the appellant's case here, is that if Denton were applied, they say they should have won the application, so it must make a difference. I think then, if I could take your lordships to PXC, which is the case of Judge Dias. It's at tab 9, page 171. And the part of that case I'd like to take to is page 184, paragraph 32. And that starts, I've concluded PXC's case is not a relief from sanctions case. We've dealt with the point why, most obviously because there's no reference to 3.9 in part 13. But there's also an existential question about the nature and function of a regime under 13.3. And my judge's purpose of 13.3 is correct justice, and that's what the White Book says. What does that mean? To surely include, where possible, the right or just result is reached. And there's a party that's liable in law is held liable in law. The party is not liable in law because it never had a duty to the claimant is not held liable. A default judgment, unless disturbed, is terminatory on liability. A defaulting, and as I've said before, there's no provisions for appealing it. A defaulting defendant carries the weight of such judgment, whether objectively liable or not. If such defendant is not actually liable, it can seek to set that judgment aside. It can avoid that injustice. And there are 3 steps to such a rebalancing of the scales. First, it must demonstrate real prospect of succeeding in its ambition of defending the claim. Second, it must persuade the court that weighing all the factors, including the character and extent of the delay and its impact on the claimant respondent, the court's discretion should be exercised and favour set aside. Third, it must succeed at trial. So again, what he's concluded is that the discretion is unfettered. It's all the factors. There's no reason why it should be informed exclusively by the Denton test. Of course, post-Denton, it's incredibly important that the courts enforce rules, practice, directions and orders. And 13.3 expressly includes that it should be done promptly. But he's saying that's enough. You don't then have to exclusively use the Denton test to inform the discretion. paragraph 33, he says, I take the policy of Part 13 to avoid injustice as an expression of the overriding objective requirement to deal with cases justly and fairly. Then he looks at Denton. He also looks at Piemonte. At 47, paragraph 47, on page 190, he talks about why he also doesn't consider Piemonte to be binding on him and why it was obiter by looking at what Mr. Justice Ida actually concluded. He makes the point that I made earlier that met with some resistance, that the fact was that the court didn't need to decide the point to dispose of the permission to appeal application. It failed on the basis that there was no real prospect of successfully defending the claim. So at the end of 47, he finds it was obiter. And then at 48, I say that he sets out exactly what the test is, and that it's injustice is avoided by having the Article 6 right to have it advanced in front of the court if A, it's of sufficient merit, real prospects, and B, if overall those merits outweigh countervailing considerations. As the White Book states, the discretion is unconditional. I take that inbuilt latitude to exist so the court can be sensitive to the infinite variety of facts and factors and the ever-changing combinations. So I would endorse his analysis there that yes, the Denton approach and ensuring that promptness is an important consideration, and you look into the extent and nature and character of the delay, which will involve considering many of the Denton factors, but that is part of the overriding objective, not just the test to be applied. He also, when he's talking about promptitude, I think sets out the position correctly at 49 and 50. I turn to my approach to the question of promptitude. I do not find this as a separate test. In other words, I do not find there are two limbs to setting out default judgment: first, real prospect, and second, prompt. And then, promptness can override prospects. And then in 50, I make it plain there is not a dual test with promptitude condition precedent. If you fail to be prompt, you are not necessarily deprived of a set aside, but you may be. The court's duty is to have regard. It is a duty to weigh and assess. And that's actually what Piemonte says. It's a duty to weigh and assess. And in my submission, that's really relevant because the 13.3 test, ultimately what you're looking at here is a real prospect of success. That is the first expressed part of the rule. And then for that to be given lesser weight on a Denton test analysis at the second stage can't possibly be right. And the appellants are contending that's the position. You look at prospects, but then you don't weigh them in the balance. I think the authorities are quite clear that where there is a case where there's very good prospects of success, that is a significant factor in favour of setting aside, and that may well override the delay and other factors. So you don't just park the real prospects of success element in the first stage. It's there throughout a single test of balancing all of those factors. And the final part of his decision that I'd like to take you to, well, actually, is page 200, paragraph 81. And he's just evaluated real prospects of success before this, and he has found that there was a fundamental lack of promptness. The delay was inexcusable, delay of 9 or 10 months. Then on page 200, he applies an unfettered discretion. And there's nothing difficult about doing that, such that it needs to be informed by the Denton test. The judges are very adept at applying the overriding objective. Paragraph, moving over to page 201, at 89, he talks again about how the Denton ethos, rather than the Denton test, now permeates civil procedure and decisions that are made, and promptness matters, very important factor, nothing less. He quotes from a case of Mr. Justice Nucci, which talks essentially about disproportionate consequences.
Maybe we should come back to this at 2 o'clock, Miss Ennis. Thank you.
My lord, just before your lordship, you wanted to have the old wording of the.
I've been sent it.
You've been sent it. It's actually in Mitchell, which of course is the one.
It's in Mitchell. Yeah, I've been sent Mitchell. Thank you very much.
Au revoir. Goodbye.
Yeah, well, you do.
We do.